and he's our local attorney that's going to help. He's on the iPhone 2 there, and Brian is in the insurance business, so he can help. So I know who they are. Jim and Joseph, if you could tell me who you guys are, that'd be great.
I'm Jim Nicholson. I do residential sales for Tech Painting Company. We're commercial and residential painting contractor serving the DC area, also Richmond, the Outer Bank, and the Outer Banks.
Great. Thanks for joining us.
Thank you for having us.
And I'm Joseph Chapman. I'm an insurance producer with Danaher Skews, a division of World Insurance, and I'm located here in Alexandria, Virginia. And I am the secretary for the group.
Great, thanks for joining us.
Absolutely.
Since we have an intimate group, I'll just start by saying, this is a very common and important issue, and it's kind of ubiquitous to small businesses. And I get what happens, which is, you start out and you're like, hey man, if I could save a little bit of money here, not pay the workman's comp and the this and the that, the Social Security, then I could save a few bucks and let's just make them a contractor, which is what a lot of people's mindset is. And you can't just make somebody a contractor. They have to, and and I'm not here to tell any legal expertise because we have somebody here to do that. But it really has to be past some smell tests. So, and Thomas, correct me if I'm wrong on any of this, but basically, if you're telling somebody to show up every day at 8 o'clock and you're telling them where to go and how much to work and things like that, it's probably not a contractor. It's probably a employee. You're treating them as an employee, especially if they don't have any other work. If they have the ability to lose money, then they are a contractor. If they don't have the ability, they might be a contractor. If they don't have the ability to lose money on a job that it can only be profit, then they're probably an employee. There are lots of ways that we can all kind of convince ourselves of things and say, well, we're not going to get caught. No one's going to be checking, but people do. There are audits, there are things like that. And the penalties are pretty severe. And you really just don't want to go down that path. And to me, it's more of a discussion about how and why your strategy is like that. And why are your margins so tight? Why can't you make more money? And why do you make this an issue that is really, a potential landmine? So, Thomas might be able to tell you, well, I'm sure we'll be able to tell you a little bit more about, the more black and white of it. But to me, it's really a simple thing. If somebody, if it could act like their own business, and they could lose money and on a job, and they're bidding things that you're getting estimates for them as kind of like a subcontractor, then that's more legitimate independent contractor work. If you are just telling them, hey, go to this job on Thursday and this job on Friday, things like that, there's a lot more risk. And then there are the people, again, this that I talk to, that just say, oh, this person doesn't have papers, and so we made him a contractor. And I'm like, you don't want to get into that kind of stuff. Make sure people are licensed, make sure people are legal to work. And the risks and penalties are just way too severe to get involved in any of those things. So Thomas, do you want to jump in and share some of your thoughts?
Yeah, so a lot of things he said was absolutely 100% accurate, right? The IRS has a whole factor test on whether somebody is an employee or a true 1099 contractor. In our firm, just kind of as a baseline rule, we break all those down to, it comes down to control. So how much do you control that individual? And based on that analysis of how much you control them will give you a pretty decent idea of whether they're a contractor or not. So some of the things that Asif has already said, do you tell them when to clock in? Do you provide the hand tools? Do you provide all the materials? Do you give them any kind of vacation? Those kind of things all make somebody really look like an employee. States and the District of Columbia are all cracking down on this. Back in 2020, the Virginia legislature passed some statutes that essentially shifted the presumption of whether somebody is a 1099 or not. And they basically, amongst a lot of other things that are very important, they said there's now a presumption that somebody is an employee unless the contractor, in my case, I represent mostly contractors, unless the employer can prove otherwise. So the shift, the evidentiary shift has happened from employee prove that you are a contractor to now employer prove that they are a true contractor. And so that was pretty fundamental and a pretty major change. The other thing that's important for a lot of the people in the construction world to keep in mind is there's now a new presumption that if you have somebody that is solely working for you in a 12-month period, they are presumed to be an employee. And for a lot of these subcontractors that work for the generals, that's kind of the case. And so you really need to look at that and do an analysis on each of your people to know whether they are truly an independent contractor or not. We also do have a lot of enforcement going on. DC in particular is really cracking down. We have 2 cases in our office right now where they've gone after our clients. One is being charged with 90 charges of wage theft, and they call them a couple different things, but it's all around not paying overtime, not paying minimum wage. And so the violations for that, you're looking at a statutory of between 1,000 and 5,000 per violation. So let's look at that numerically. If you have 90 charges and they were, let's just say for this example that they are actually correct, then you're looking at a fine of $90,000 to $450,000. I don't know about you, for most of your companies, that will put a lot of these small business owners out of jail or out of business. And the Attorney General in DC is going really heavy on that. So you do, and Virginia and Maryland as well, they're cracking down on it too. The quote unquote benefits of why people do it, beyond the things that Asif has already said, but is you don't really typically have to pay a 1099 contractor overtime. So that time and a half doesn't apply to them, unless it's contractually between you all that you will pay that. And so that's where that wage theft starts going.
Not to mention they're avoiding paying the federal taxes, state taxes, all that as well.
Oh yeah, absolutely, and that's its own
The matching.
Yeah.
And the federal government frowns upon them not getting paid, and don't look highly on that.
So like a couple things that we look for when a client comes is like, okay, who are you paying? Meaning, are you paying this person in an individual capacity, or are you paying an entity? So if you're paying an entity, that tends to lean towards you're doing a contractor. That is not dispositive that they are contractors. It's just one of the multiple factors that you look at. So I don't know if you guys, I was a little bit of a side note, but related. I was on Facebook the other day and I saw a company advertising for ways to pay to give your 1099 contractors health benefits through your company. I was like, whoa, do they know what they're actually saying? Like, I didn't dive deep into it because it was an ad and I don't click on those, but on its appearance, it made it look like the general contractors were giving these 1099s healthcare through this company. And that's just the kind of stuff that really kills your analysis if you're trying to make sure that you actually are truly having independent contractors. So we always encourage our contractors, if they're going to hire 1099s, make sure that you're paying an entity, make sure that you get insurance and a certificate of insurance from that person or that company. Make sure that you're getting a W-9 and that you have all that stuff in place. It'll help your defense if you have to get there at some point.
Let's add a subcontractor agreement to that as well.
Oh, 100%. Absolutely. And we always put in there a lot of language to try to say, look, we don't care about the means and methods. We just want the task done. Now, that doesn't mean that you can't tell them when they have to do the job. You can certainly give them a schedule, but a schedule of when the job has to be completed and when the job site is available for them to work is much different than saying you must be on site at 8 a.m. Instead, it would look something like the job site is available for you to work from 8 a.m. to 5 p.m. After that, the job site is closed. You can't work for the day. And so I don't want people to walk away going, well, if I can't tell them when to show up, you just have to do it in the right context and the right framing and understand what that means. It's not saying you have to be here at 8. It's simply saying, I don't care how you get the job done, but you only have this long to do it. And these are the access times to do it.
The other, in construction, the things that I see, or remodeling, the things that I see are, with field labor, obviously, people trying to determine if somebody's a W-2 or 1099, and then also with relation to outside salespeople, and then administrative support, your and kind of internal help. Typically your accounting CPA is always going to, typically you don't have, that's going to be an outsourced person, and that they're not going to be, they work for multiple companies. So it becomes an obvious thing. They have a separate company themselves. That becomes obvious. Sometimes you might have a bookkeeper and you're saying, well, I'll just pay them as a 1099. Well, if that's if the bookkeeper only works there and not for anyone else, it starts to become a gray issue. And if they're also getting some bonuses because the company's doing well, things like that, it starts to really get very shady. And if they have no way that they could lose money, again, areas of concern. There are sometimes people that have commission-only salespeople. Again, what Thomas was saying is, are they going out and doing their own thing? They're deciding, hey, I'm going to join this group, and I'm going to go find my own leads. I'm going to do this or that, and kind of harvest what I plant. Then there's more room for discussion about 1099. But if you're telling them, hey, you got to go to this meeting and this appointment on this date and meet with this person and say these things, then they're closer to the W-2. But do you have some thoughts on those two examples, Thomas?
Yeah, and so one misconception that I see a lot with my clients is that salespeople have to be 1099, right? And that's not true. You can actually have it's titled as an outside salesperson. An outside salesperson is somebody who does not sell from the principal place of business. So if you have a showroom and they're selling in the showroom, that is not classified as an outside salesperson. That is the person that leaves that principal place of business and goes and sells inside the home, for example. Okay, that can still be a W-2 that is paid based on commission. It's a special carve out in the employment law. And so we try to have our people do that. Now, you do, when you pay those commissions, you got to take out the taxes and do all the right stuff as an employee. So some of my contractors still give me grief about it, but we try to push people with their salesmen to do that rather than just throw them on a 1099.
Now, one of the things I was running into recently is somebody that would kind of pay somebody hourly for their time, plus give them a commission. The individual was able to kind of make their own schedule, decide what appointments to take, not to take, and they were treating them as a 1099. If they go take somebody to lunch, they expense it back to the company. In legality, how do you see that, Thomas?
So that's kind of a finer line there. Yeah, I'd probably want to know more facts. So the fact that they are paid an hourly basis, could be very consistent with a consultant, right? Lawyers are consultants. We bill by the hour, right? And to then get a commission isn't inherently a bad thing. That's very similar to if like our firm took on something that was partially hourly and then a contingency kind of bonus, right? So that in itself is not really hurting my heart too much to say that they could be a 1099.
Yep.
When you start saying I have an expense account, and if I take somebody to lunch, I put it on the corporate credit card. Now you start getting into that employee realm. So, again, I'd want to know a lot more facts. These are not, and let me be clear, these are not simple things. You certainly have your one end of the spectrum and the other end of the spectrum, but a lot of your analysis is going to fall somewhere in that middle gray area where are they classified truly as a 1099 or are they a W-2? We always tend to lean on then put them as a W-2 if you have any question. You won't get in trouble for paying them, maybe more than they should. The government won't care about that. The only government cares when they get stuff taken away from them.
Right. I see we've gotten a few other people that joined. I'd love to hear from you and hear what questions or challenges you might be facing in these areas. I see a Randy and a Sean. Sean, do you want to say something?
I just joined here, so I'm sorry.
That's okay. Thanks for being here. Tell us what kind of issues you face with relation to employee versus contractor.
I can jump in. I'm Sean's partner. This is Randy.
Hi.
Hi. So we own a business. We have about 50 employees, maybe less, 35 employees, 15 ICs. We fabricate countertops, granite countertops. Let me put my my video on so you can see me. There we go.
Thank you.
All right. So we're in Herndon, Virginia, and we used to have the installers, the people that picked up the granite countertops at our shop and go out to the customer's home and install them. They used to be employees, but then it got to be where the installers in the Northern Virginia area kind of talked to each other and they all wanted to be ICs. A few started at first, and then over the last 8 years, pretty much they've all fallen in line and they want to be ICs. So they come to us with insurance, workman's comp, business license, of course, general liability insurance. They have their own truck, they have their own tools. However, we're in that gray area because we give them a daily schedule. We say, you have to go out to Mrs. Jones, Mrs. Smith, and Mrs. York's house, more or less in this order, and install these countertops. And then we pay them per piece for the countertop work. They have helpers. So there's 2 people in a truck. We pay the company as an IC because they all have company business licenses, and they pay their helper. So we want to be legal, but we're not sure about it.
Well, so in this case, you're paying a company that has insurance that is a legal entity, correct?
Correct.
And they have their own insurance, and you have a contract with the company to do certain jobs.
That's correct.
Is there a contract for each job, or is it just a general contract that says, here, you're going to do this fabrication work for us or installation work for us?
It's a general contract. It just says we're going to pay you so many dollars per square foot that you install, and that you don't work for the company. You're an independent contractor. You have to have your own insurance. It's something we pulled off the internet. It's about 8 pages long.
Well, You know, from my point of view, I think you're much safer because they've got subs that they're paying. They've got people that they're paying, correct?
Yes.
So you know, I think it's a lot less gray, and they've got their own insurance, and they've got their own kind of potential to lose money, right? Because you're paying them a fixed amount.
Paying them a fixed amount, and they do lose money. If they break the piece, they have to pay for it.
Right. So Thomas, do you see any issues with this one?
So I like a lot of what I'm hearing. I think for a lot of it, you're good. A couple of clarification questions. You said you're in Virginia.
Yes.
Do these installers work for any other company?
99% of the time they work for us. Sometimes they'll do work on the side for the customers that we send them to. Sometimes they will work for other companies like us, like on a weekend or something, but not often.
So I'm not sure if you were involved or on the call earlier, but I was telling about the group about how Virginia in 2020 changed their legislature and created statutes that essentially said that if a independent contractor works solely for you in a 12-month period, that they're presumed to be an employee. So having them work for, and these are new laws, right? So there's not a lot of cases that have been gone through and go, well, how many other people do I have to work for before it's considered, safe, right? But the more that they do those side jobs, the better protection you have against them being classified as a misclassified employee. So it sounds like you're just paying a company and they're paying for all of their own people and their own trucks and all that. So I think you're set up pretty well. You said you haven't signed a general agreement. I don't know if you haven't signed something like a project specific task order. We call them task orders in our firm that say, this is the person's house you're going to go install. This is what you're going to install. And this is the compensation we're paying you. But those in themselves are fine to have general agreements.
The other thing is like you were just saying, having bills, and like an employee typically doesn't send a bill to their, they might fill out a timesheet, but having invoices and making it arm's length transactions obviously help with the cases. And each job being its own separate thing makes it a better thing as well.
I understand. Thank you. That helps.
Great.
We don't require them to work exclusively for us. But one thing that somebody had brought up in the past was because we are a schedule and we tell them which jobs to go to, they thought that might be a red flag because they're not scheduling their own time. Is that true?
Yeah. So the way I look at it is you're not telling them you have to be at the office at 9 a.m. I mean, what you're essentially saying is you have these projects, right? And any project, right? Like whether it's remodeling, whether it's a road project, or you're building, a commercial building, all have schedules tied to them. So the approach I would take is that is simply nothing more than a schedule of when it can be completed. I'm not sure I would necessarily say you need to go to this job first and this job first. But if you say you have a window of between 10 and noon to install this piece of countertop, I don't care if you do it at 10:30. I don't care if you do it at 11. I don't care if you do it at 11:59. But you have to be done by noon because that's the schedule you have. Is that going to be the biggest red flag you have? Yes, but again, it's a factor test, meaning that there's no one thing that says, oh, you did that, therefore you're going to be hit with a misclassification. It's kind of a holistic approach. And in the construction world where you have schedules for projects, I don't think it's all that unusual.
Thank you.
I think those are some good questions. Did the others on the call have questions specific? I see Eric on the call. Anyone else that has questions that they have?
It's not so much a question. I think with, at least in the painting industry, we're similar to what's going on with Randy, where you're gonna sub to a contractor who has a license. He's got insurance. We demand it if he's gonna work for us. He has to have those things. He has to have workman's comp. But essentially, if I go out and bid the job, say a $3,000 job, we're gonna take 40% of that as our cut. So essentially, the contractor is then agreeing to do a $3,000 job for $1,800. And that's what's going on certainly within the painting industry. People who use subs, they're guaranteeing their money. There's very little loss for the contractor because they're going to get their 40%. And the guy doing the work is going to be doing the work for 60% of what the market will bear for that job. I mean, Randy, I'm sure is charging, say it's $75 a square foot, something, but the installer is charging him only $50 a square foot to install, or whatever, whatever the math is, but it's something along those lines but these guys, your guys, Randy, are asking to be in this situation. For us, we have almost all of our employees are W-2. So in order to have W-2 employees, we have to carry equipment. We have to have ladders. We have to have trucks. We have to have insurance and all that stuff. We have to have a warehouse. If we were operating, need the warehouse. I'm sure, Randy, it looks like you're working in an office. You probably don't have the cutting tools anymore, or the trucks that have to carry the countertop. Is that right? I mean, that's.
No, it's a little different. We have a factory and we actually buy the stone slabs. We send out different people to measure. We have people here that design, and then we have fabricators that cut the stone and polish it. So 80% of the work, 90% of the work happens here at the factory. 10% of the work is done by the installers. They just pick it up, take it out and set it in place.
So essentially their material costs are pretty low because you're providing the materials in this case. Right?
Correct. They're supplying setting materials that are directly related to their work, something to caulk the stone to the walls after they've set it in place. That's about all. And their hand tools for shaping and cutting whatever's necessary.
Right.
And carrying.
Yeah. So a couple things I'd like to add to this conversation. One is about the point of, because I get this as a defense a lot, that people try to say to me when they come and they get caught. Well, they asked me to do it. They asked me to make them a 1099. So that's not how the law works. Like, it doesn't matter. You can't, in this realm, make an agreement that you're going to be a 1099, but then treat them like an employee and feel that that's okay. I mean, that's the exact excuse that my guy with the 90 violations from with the Attorney General of DC, is exactly what he told me. And the problem is that's not a defense. So keep that in mind. It's fine if you guys agree to an independent contractor relationship, but you just have to treat them differently. Okay. And then Jim, to your point, you're a little bit different than what I see in the construction field, in the residential construction field. Most of my contractors do not hire licensed subs that have all of the insurance and everything. Sometimes they'll have insurance, but I see it quite often where these are just essentially people that show up and they'll do the work, but they have no license, they have no real business to speak of, and they just show up and do it. But that's just, I think, inherent in the construction industry, from what I see.
And that makes sense to me that that's illegal and it shouldn't be done. I mean, that's definitely crossing the boundary of wage theft and not paying overtime. And also, how are those guys protected if they fall off a ladder and break their neck or anything catastrophic? I understand that. What I guess in our industry, what is more, I don't know, it's kind of goading to me because we're paying for all this. We have all this overhead of all this stuff that we need to have. We have to have ladders for all our guys. We have over 25 trucks. It's a lot of stuff that we're carrying that contractor. And I'm gonna call out CertaPro on this. CertaPro, they use subcontractors who are legitimate contractors, but they don't have to maintain a warehouse, CertaPro doesn't, nor have to maintain ladders or things like that. They have their sales guy's car and that's it, and their location where their office is. And that's all their overhead, essentially. Everything is really on the backs of the contractor who's going to do the work for 60% of whatever the job cost or would bear, what the customer would pay. So I guess there's nothing wrong with it. It's just, it's difficult to compete against contractors like that, especially if they could say underbid the job by $200 or $300. They're still going to get their 40% of the amount for essentially just finding the job and billing it. And then us that are paying for all this overhead. That's our, there's no law being broken. It's just a law. It's just the way the law works, I guess, in this case.
Yeah. Joe, did you have any thoughts or questions you wanted to share?
Yeah, absolutely. I mean, again, my jumping off point in this discussion is really about the workers' compensation. For me, at the end of the day, one of the things that I like about employers is really to think the job through when you're hiring subcontractors, or if you want to consider someone a 1099 and where those rules fall in. And what I'm looking for in Jim and Randy, you both hit on this, is do the people you hire have a business license, but more importantly for me, do they have workers' compensation? That's where I'll see the problems arise most frequently, is going to be in that workers' compensation realm. Sometimes it's damage to property done by a contractor, but usually the owner can step in and fill in that gap. So it's workers' compensation and the loss is there. And, for my purposes, what I like to tell people is it's for workers' compensation, they're an employee of your company and they represent your company on that job, and they're going to be applicable to your workers' compensation insurance unless you've asked for and received a copy of their insurance indicating that they are currently covered for workers' compensation. And if you don't receive that, and if they don't have it as a GC on the job, when you accept the job and they get into an accident, even if, and I've seen this fairly recently within the last year for a roofing contractor, they brought in someone who they thought was insured, who provided a COI. The person themselves may have thought they were insured. And the policy lapsed between the time that they got the COI indicating they had coverage and the time of an accident. So in this case, the accident happened. There was some serious damage to the employee. He fell from the roof, and the claim was billed to the GC on the job because he's the one who had the viable workers' compensation policy. So the employee is covered no matter what. It's the same thing if you're a homeowner and you hire someone that doesn't have insurance. If he falls from the roof of your house, you're responsible for his medical bills. And that's the reason you should always ask for that coverage. And it's important for you as a GC or someone hiring 1099s to make sure that that coverage is in place, or assume that you're going to be billed in the event of any accident for that loss. So that's always something I like to bring up to clients.
Yeah, I think those are all very important, relevant facts. Thank you for that.
Yeah, not to go too down that rabbit hole, but just I'll add a little quick comment. And we certainly are not. I'm not an expert in workers' comp, but we have dealt with some cases where people have fallen on a job. They were a sub to my GC, and basically there are things called statutory employers, which fall into the workers' comp realm, which basically says that even though they're not technically a worker of you, you're kind of responsible for it. And so you really want to make sure you get that COI. That's a very important thing. I also encourage all my people to have on that COI, have the GC, if I'm representing the GC, have them listed as an additional insured on it, so that we can look at that COI, and it's usually down in like the left-hand corner, to have your name visible right then and there. That gives you certain rights.
Yeah, I mean, we tell our clients, most software does this now, most accounting software does this now, to not pay people unless you have a valid certificate of insurance on there, and a current one, so that it's like a red flag. You can't pay this person unless you have the right paperwork. That's one of the things that we would advocate. You know, a general contractor, if they're building a house, for example, you know, you're typically going to get 3, you know, estimates for each trade or each function that needs to happen. So if you're not doing that and you're always giving it to the same guy or the same people, that's probably a flag. You know, if you only have one plumber that you give everything to and only one electrician that you're giving everything, one drywall guy. Part of the issue is, why are you doing that? You know, we work with people on strategy. So are you missing something there? Are you missing an opportunity to save money and, you know, spread out the work with people and see what else you can get and better pricing strategies? Are you keeping the people honest, not just from a, you know, a 1099 W-2 point of view, but, you know, are you getting the best pricing? So when we talk to people, it's a lot about the strategies overall, the macro level thing. And a lot of these things kind of get answered in that process when we talk to them. So
that's a great point. On my side, when I ask something similar, it's usually this person is good, proven quantity to me, right? Like they've done good jobs for me in the past and I trust them. And I say, that's great. Maybe you should make a W-2 if they're going to be that great for you. But I do think it's wise to spread around the wealth. I'm sure you've all heard this. And if you're in if you're a contractor, you've certainly felt it. You know, labor is hard to find in general. So if you have somebody that's a good proven quantity and they're available to you, they're gold right now.
Exactly. So why would you want them to potentially go to work for somebody else? The cost of trying to, you know, find somebody else or rehire that same person if they're available is huge. So sometimes, you know, if the work there's gaps in work, you know, we encourage you to hold on to those people and, you know, work on your sales processes and marketing things then to avoid those gaps so you can keep people busy all the time. So it's not a singular question, this issue. It's a macro level question that has a lot to do with all of the functions within your business.
And a lot to do with the industry. I mean, as Jim pointed out, it's a race to the bottom when it comes to dealing with a lot of residential remodelers. It's a race to the bottom. Who can get the cheapest? And homeowners will, setting aside the idea of quality for a second, you know, will think, well, everybody does it the same, but if I can save $100, I'll save $100, which is a shame. They really do need to consider about, like, what are you getting for that money? I pay for.
Well, I mean, that's the key thing that we talk to our customers about. You know, are you in the right house? Obviously price is always an issue, but if the person is strictly basing their whole decision on price, you're probably going to run into a problem. And if it is a race to the bottom, why do you want to be in that race? You know, I can sell a lot of work really cheap, but that's not really being a salesperson. You know, a salesperson knows how to sell things at a value proposition, at a high, you know, revenue and a high profit margin. That's what real good salespeople do. And that's what we talk to people about. So part of the thing is, if you're basing everything just on price and not quality, not timeliness, not, you know, the products that you're using, the materials that you're using, you know, hey, we background check our people, we do this, you know, they're legal, all of these things, they're fully insured, they're licensed. All of these things are all things that homeowners are going to be looking for. And, you know, they don't want somebody to fall off their roof and not be insured, like Joe was saying. So no one wants that, and no one needs that. So do we have anyone else that hasn't had a chance to ask a question or share their thoughts? Any other thoughts from any of you about this topic or things in general in the industry right now?
I have a question. In case the government gets on you, they say, okay, you've misclassified. So what are the fines? What are how far do they go?
Good question.
Yeah. It's
Thomas, I think you're going through a bad area. We are having trouble hearing you.
His car must actually be moving now. He's been sitting on 95, I think. Still not working.
You still there?
Yeah, I'm still here. Can you hear me a little bit better now?
Yeah, thank you. Go ahead.
All right, sorry about that. There was a dead zone near my house. But yes, the fines are massive because typically when an organization like the government comes after you for misclassification, they're not looking at you because you're small because you misclassified one person. So like we have an electrical contractor right now who is under investigation by DC Attorney General, and they're going to get hit with 90 plus violations. And each of those violations by statute carry a minimum of $1,000 and up to $5,000. Now that's just the violation fine, right? So in my current example, my guy's looking at paying out between $90,000 and $450,000 in fines. The other thing to keep in mind is they want you to pay those back missing wages. So if you owe overtime, if you didn't pay minimum wage, all that's going to need to be caught up and paid to the employees. They do want the employees to also be made whole with these investigations. So, and that doesn't even touch on the amount of money you're going to spend on legal fees to try to protect yourself and defend that. Certainly looking in the $20,000 to $40,000 range, depending on how far the Attorney General wants to take it. That's the side of where the government is coming after you. You also could be at exposure for private lawsuits from your independent contractor, who maybe you terminate and they get upset. They run to a lawyer and the lawyer says, hey, you know what? You might be entitled to compensation because they misclassified you. So let's go sue them. And what's really interesting about those is they can ask for triple damages. So let's use a simple example, right? You didn't pay them $1,000 that they were supposed to get. Well, they're going to ask for $3,000 plus attorney's fees. And a lot of those attorneys will actually take those on contingency fee agreements, which means that they'll get like a third or something. So they're getting a lawyer for free. And so you'll lose a lot of leverage that sometimes you'll have if you're going up against another side that doesn't have as deep a war chest as you, in that they might be getting their attorney for dang near nothing. So it can be very, very damaging, which is why it's such a serious topic that's not talked about very often, unless you actually are hit with some kind of investigation from an attorney general office or a lawsuit.
So
Yeah.
is it a DOL issue or IRS issue or both?
Well, that could be all.
Yes.
Yeah, the answer is just yes. I mean, the IRS can come after you for some kind of evasion of tax. I'm not quite sure, but where we typically see it in our law firm is coming from the attorney general for the wage theft, and then from individuals themselves. But there's nothing stopping the IRS from coming in after you as well.
Well, the issue with the IRS becomes, the avoidance of paying Social Security tax.
Correct. Yeah.
From the employers. So they want their share of everything. So if you're doing it for that purpose, and people start to talk and people start to just say things that are completely inappropriate, and that's part of the trigger that happens. And sometimes you hire somebody and you're friends until you're not. And like he was saying about a disgruntled independent contractor, they get a lawyer and you're paying 3 times the output plus the fees for the legal things. So you really have to be careful. And a lot of times people are just, spouting off at the mouth at a bar or something like that about things that they shouldn't be bragging about.
Yeah, one idea or thought, and again, it's part of the growth of this conversation, has kind of made me think about, It's just sort of the insurance coverage. It's something you can look at in your own policies. If you guys have an employment practices liability policy, which is fairly common, but certainly with contractors bringing in 1099s, it might be more important for you. But take a look at the language of the policy itself. And there's two ways it can be written. It can be written, you know, as a general idea of an employee, which is clear, but they can also be written to include people who do work for you. So they can include volunteers, they can include contractors, they can include subcontractors while they're under contract with you for a piece of work. So, you know, as far as the legal bills, at least there's a remedy there, insurance wise, that many of you probably already have an EPLI policy, that you might want to look at it just to see what that definition is for what they consider, you know, consider for coverage under that policy.
And Joe, that's a fantastic point. That is a very good option. One thing that I saw back in 2020 that like shook me to my core right when this legislature had passed this new law in regards to if you are working solely for a single company, you are presumed to be an employee, was we went and looked at my client's EPLI policy, and it defined an independent, it said an employee is a typical employee, but it also includes an independent contractor who works solely for the business. So now what you have is, in my client's situation, you had a unique thing where if I don't have my independent contractor work just for me, then I have a better argument against the law that says that I have the presumption that they're an employee. However, I may not fit the definition of an employee under my policy. So really, I mean, as Joe said, you got to look at what your policy says, but it put us in a really interesting position. We had to have the client make a business decision after assessing all the risks. And the decision that my client ultimately made was, I need the insurance policy to make sure it covers me. So they kept it as was, where the independent contractor was working solely for them.
Yeah, good stuff. See somebody else on the call. Adriana, is it? Did you have any questions or anything that you wanted to bring up? Maybe she stepped away for a second, but anyone else that has questions or thoughts?
Yeah, I'm not sure if this really pertains to the conversation. It has to do with workers' comp. It seems like our ICs don't want to buy the workers' comp that covers the principals. So we had a HVAC guy come in. He also does our plumbing. I'll give you an example. We install a countertop. Sometimes the customer wants the plumbing hooked up afterwards, and we send this IC out to do the plumbing for him. He's a plumber. So he also does HVAC. So we had him come into our shop to fix our HVAC, and he hurt himself. He was up in the air and he hurt himself. And his workers' comp insurance did not cover the owner of the company himself. I don't know what our liability was. It turned out our insurance company said, we're not going to cover you, and he accepted that. I'm not sure what would have happened if he'd have sued us though.
No, I mean, generally that's a choice. I mean, from my perspective, whenever I've seen it, it's a choice that anyone who buys a workers' compensation policy, the owners or board of directors can choose, depending on how the legal structure is, can choose to opt in or out of the policy, but it's their choice, and they're opting out should. Now, I wouldn't guarantee it. I mean, that's for someone else. But whenever I've seen this, since they chose to opt out, there's no liability on your part if they're doing work on your site. And some people, really small operations, may buy, and even the contractors that you guys could hire, they might go out and get a ghost policy. And a ghost policy is roughly determined as a policy for one or maybe two people that excludes them both from the policy. So you have a policy that exists for contract purposes. They can do work for you because you require a policy, but it in essence doesn't cover anyone. They're just paying so they can get jobs, and it's fairly common with very, very limited size operations. But once they hire even a single employee or have someone who can qualify as an employee under workers' compensation, then they need to drop that policy and get a regular workers' comp policy. But they could still exclude themselves. So I would think there wouldn't be any coverage, but at least when I've seen it.
And it's very common for the owners to exclude themselves. They're the only ones they can exclude themselves. And if they're hands-on, it can be very expensive. I mean, in different jurisdictions, depending on what the limits are of payroll, let's just say somebody pays themselves $100,000 a year and their rate, they're a carpenter and they got a 10% rate, that's $10,000. They're paying in workers' comp just to insure themselves. So it's very common for that to take place.
Thank you.
Good question.
This is Eric. I have a question that's a little bit off topic, but it goes down the workman's comp angle here that we're talking about. The question is, we have some independent contractors and they're doing a relatively large volume and they're doing some various types of work, but is there a way to split up a workman's comp policy so they're not paying 100% on, let's say, roofing, which is really expensive? They might only be doing 20% roofing and let's say 80% siding, just to make it easy. But their workman's comp policy tends to be really high if they're all under roofing. So really, they split that out for an independent contractor for them to do it. Obviously not us, but.
Yeah, I mean, it depends on the class code. Some class code, and so every job's broken up and it's given a class code by NCCI. So every job's going to have a class code, and it really depends on that class code and how NCCI wants you to be able to, like you said, split it up. Some class codes don't allow for splitting, and some class codes do, and some of it comes down to the carrier and what they're willing to allow. But generally speaking, especially when you have something that's doing two very, very unrelated things, yes, you're able to split it out. But it really comes down to that class code definition. And if you go to ncci.com, there's a way that you can get on there. You can email me and ask me. And you can look up the specifics of the class code, even if you Google it. Once you figure out the class code, if you can Google the class code, it'll give you a definition of what's allowed to happen, and whether or not you're able to split it out. But it's not uncommon for operations that do multiple things to be able to split out the jobs differently. It's a little bit trickier when you have an individual employee that does different things. And then even where sometimes it's allowed to split out an individual employee, there has to be record keeping in place to track all the times that he was doing something different outside of his class code. So, you know, I guess that's a muddled answer, but I guess the answer is maybe. But yeah, there's generally some ways to split it out.
Thanks.
You know, I guess a lot of these things are gray areas and discretion. And, you know, my thought process is you just don't want to be in a situation where in anything where somebody else, you're at the mercy of somebody else's judgment. So it's better just to be on the safe side with everything. What other questions or thoughts do we have today?
Earlier, you had mentioned the ICs would be looked at more as ICs if they presented a bill to us. Currently, we don't do that. We calculate how many square feet are in a countertop and we pay them X dollars a square foot. But it sounds like we should have them present us a bill for that amount.
Well, you know, like Thomas says, I don't think there's any one rule that makes or breaks, you know, makes it, but I think it's a cumulative effect. And think about it again, if you are a large company or a larger organization, and you're building a house, so you'd get a plumber to do the plumbing work. You might get 3 estimates and the plumber would submit a bill to you. And you know, once the work was done and you approved the bill, then you'd pay it. You're not just going to pay people for, you know, just because for the heck of it. So to me, it's a safer way to go. But you know, I'm not the attorney. What are your thoughts, Thomas?
Well, I think it's also just a good practice because it can help
narrow down any disputes about whether it was the right calculation or not. If they submit a bill, I'm just going to make numbers up, right? If you calculated that you only are supposed to pay them $100 and they submit a bill to you for 110, well, now it's a little bit more clear that if there's going to be a dispute and you can get that resolved a lot quicker, then here's your check for $100, and them go, well, what do you mean? I think it's 110. So I think it is probably a good practice all the way around as far as the independent contractor versus employment is concerned. But I think it's also just a good practice to help negate any potential disputes regarding payment and amounts.
Yeah, that's a very good point, of course. So there's no room for misunderstandings.
Okay, thank you.
Good question. Other thoughts? Jim, did you have anything else you wanted to bring up or questions?
No, I think you covered everything I was concerned about. Really appreciate leading the discussion, both you and Thomas today. It was awesome.
Pleasure. Anyone else have anything?
Well, I'll just leave everybody with these kind of parting words. I would certainly, if I were on this call as an employer, I would take the time to look at your structure now and maybe run it by some advisors. Just if you have questions, just to get them answered now, and if you have somebody that is a questionable, are they really an independent contractor? Are they employee? It is certainly better to get that knowledge up front so you can fix it if it needs fixing, than to have somebody else tell you that it was wrong later on. Not saying it won't happen. I mean, you can sue for anything, but they do have to make their case. But if you know about it now and you can start fixing it, you can mitigate any potential problems down the road.
Along those lines of thought, I have a question. Someone recently asked us, another businessman, do you have a ruling from the government that your ICs are in fact ICs? And I said, no, that seems like it would open a can of worms. What are your thoughts on that?
Get a ruling from the government?
Yeah.
I've never heard of that, to be honest. I don't even know where you'd go.
I mean, I would only think that would be something that would come up if you were audited or if you were questioned, and they, as a result of that, they said, no, okay, if you pass their smell test, so to speak, you'd get that.
Yeah. I certainly would not be going to any attorney general's office and saying, hey, why don't you come and look into my, look under the sheets here and see what you can find. I wouldn't do that just from what if they find something wrong situation. You may be opening yourself up to a bunch of exposure, but I've never heard of getting it ahead of time, saying that they're certifying, because these things are a factors test, and there's not one thing that determines if somebody is a employer or an independent contractor. That's great. They may be deemed an independent contractor today, but if the facts change tomorrow, you may have a different situation.
Yeah, absolutely.
Good advice. Thank you.
See, Chris just joined. Chris, welcome. Didn't know if you had any questions or things since you just joined. Anything you wanted to ask? If you're asking anything, you're muted, so. Okay. Anybody else? Any other thoughts or questions?
I'd just say too bad there's not more contractors on here to hear this, because I don't know if it's a chronic problem, but it's not infrequent where I just insured a guy today that was doing the same thing. I just went through just about everything you talked about. I mean, I touched on the IRS stuff, but I explained to him, dude, you're just doing this wrong. You're going to get in big trouble at some point. And so we restructured everything and how we did business. but you know, there's a lot of guys out there like that, and it's just too bad we don't get, there's not more of them that care.
Yeah, it is a real shame. I mean, our law firm represents a diverse group. We do design builders, we do exterior companies, and where I see it really is rampant is in the exteriors world, the siding, roofing, gutters, whether they do insurance restoration and storm damage repair, or whether it's the retail side. I mean, I have companies that do $30 million a year. They have 50 people. There's only one technical employee, and that's the owner. Everybody else is independent contractors. I'm like, there's no way. There's just no way you're actually treating them appropriately, knowing how you treat them. And I see it all the time in that field. I see it a little less in the design build field, but it's still pretty rampant there as well.
Did you say this was going to be recorded and would be available to folks?
Yes.
Yes, it is being recorded. I was thinking maybe some people didn't jump on because they thought, well, what I don't know won't hurt me, but it will hurt you. Yes, it's recorded. So we will get it out to both PDCA and the pro members as well.
Yeah, a couple people followed up with emails saying they couldn't attend and asked for the link for the recording, just so you know.
Okay, great.
So I guess you're sending it to everyone, right?
Mhm, yes.
Great. Thank you.
Mhm. Anybody else?
I appreciate the opportunity to chat with you guys tonight and get to know you a little bit. And I'm happy to have any offline conversations if anyone would like to.
Yeah, it was a lot of great questions. I really appreciated it.
Yeah, I will include your contact info too, Asif and Thomas and others. And so they can reach out to you if they have any questions.
Great.
Thank you, everybody.
all.
Thank you for your time.
Thank you.
Great.
for taking
Thank you,
the time.
Thomas. Thank you.
You're
Asif.
awesome.
Thanks. Debbie, if you could stay on for a minute.
Sure.
See
I'm gonna
y'all.
end the
Thanks,
recording
Thomas.
though.
Yeah, I'll
Let me
stay on.
end- Let me stop recording.